All right, so this cross-examination was definitely something to watch, and I want to break it down right now with my very special guest, familiar face here on the program, Law&Crime trial analyst Julie Rendelman. Julie, great to see you.
Good to see you, too. Hope you had a good weekend.
I do. I hope you had a great weekend as well. Now, here's my question to you. As we look at Zachary Keene's testimony, I wonder how many people out there are thinking, well, wait a second. You know, maybe if I had a weak stomach, and that seems to be a popular, a common thing with husbands or fathers of children who maybe they don't have quite the stomach to take care of a baby in the same way that a mother does, maybe. And if they gave all the responsibility to Cheyenne and he was working so much, could they possibly understand, someone on the jury, why this may have happened?
I think they could. I think the problem he has is, you know, when you break down kind of what he said, remember he had 2 children, and I believe there was some testimony that he had helped out actually babysitting for a family of other children that he potentially had changed diapers. On top of that, he walked his dog as well. And so one would imagine when you walk your dog, you have to clean up after your dog. And so, you know, the unique thing about this case that's different from, for example, what you might expect in a murder in the first degree is they're not accusing him of intentionally killing his child. They're accusing him of basically neglecting his child. And so all the things he's describing, even if he's describing it all being his girlfriend's fault, that still falls within the idea of neglecting the child.
Yeah, that failure to provide critical care becomes the key issue. You think it was wise for him to take the stand?
You know, look, I think the prosecution in this case is phenomenal. And so if I were the defense attorney, I'd be very nervous to put him up against such a brilliant cross-examination. With that said, I do think that there could be a juror or two who understands kind of what you talked about in the idea that, you know, it was his wife's job, he was the bread earner, and that it really was on her to provide those things. Although, you know, a lot just doesn't add up, and he added to it not adding up.
Sure. I mean, as you said, the idea, he worked at a sewage company, and they said, well, so you worked at a sewage company, and you could handle those feces, but you couldn't handle the feces of your own baby. And that, if that wasn't even enough, I think the thing that really stood out to people was the fact that there was certain testimony where he just didn't talk about Sterling to certain people. And a lot, you know, that was his son, and he didn't even mention it to his coworker. It becomes a bit odd. But what I want to do, I don't want to just show some of his cross-examination. I want to show more of it, because as Julie said, they did a really strong job of cross-examining this witness, and at certain points, he admitted his own fault. Let's play a little bit more of that cross-examination. Okay, let's just talk about the things that are weird. You know, Julie, we were just talking about things that don't quite add up. You said you heard him crying at 6 a.m. that morning, but today you said you hadn't. Why did you tell the police that? Well, I didn't, and I thought I had. Well, why did you think you heard him? I don't know, probably during something in my dreams. And then the prosecutor let that marinate for a second. Does this make sense to you?
No, it doesn't. You know, one thinks that, you know, as a defendant, you're sitting and listening to all the testimony against you. And so when you get up and take the stand and realize that you've made statements in the past that are inconsistent with what you've heard already, then he's trying to figure out a way to change his story. Now, obviously, the fact that he thinks he's dreaming makes not a lot of sense. One thinks that the reason he said that he heard the child crying is because he wanted to make an argument that the child was still alive up until that point. But no, it doesn't make sense, and I don't think the jurors are going to believe that it makes a lot of sense.
But you could argue that the opposite side is that he's very forthcoming with information. He's very honest about the fact that he failed in one degree or another. So it's not as if you could argue that he's hiding a lot. It's just some people have criticized him for not being all that bright and not as there. And so is there a way that the jury can look at him and humanize that aspect?
It's such a good point. He does come off as not very bright, which makes you wonder again about the idea of him taking a stand, because, again, keeping in mind this is not an intentional crime. And he's basically admitted to the crime by saying that he didn't care for the child as much as he should have cared for the child, which is exactly what the crime is. You know, on the other side, I think that, you know, many people would understand, and I without being chauvinistic, I think many women realize that, you know, there's been times when they have 4-month-old, 5-month-old children, that they wake up with the child, they feed the child, especially if they're breastfeeding, and they are usually, in certain circumstances, the sole provider for the child for the first several months of life. The problem we have here is that they lived in a very small apartment where he saw, or at least would have noticed, that the child was not appearing healthy, certainly not smelling healthy. So all these things add up to him kind of ignoring that the child was in danger.
In other words, how could you not know that there was a problem?
Exactly,
Right.
and that's the uniqueness of this type of charge.
Yeah, I mean, we have a lot to discuss in this case, unfortunately, because the details of it are so horrifying, but it's so important for the prosecution as they establish their case. But it's also interesting to see what the defense's strategy is when they put him on the stand. Let's take a quick break. When we come back, we have a lot more to talk about. Okay, so you heard found guilty across the board, and even of those other counts which he had already pled guilty to, the jury still gave their verdict on those. Julie, guilty across the board. Are you surprised given the circumstances of this case? And we know the defense was really keen on trying to point out that it was only a short time before this shooting that there was an officer-related shooting where they shot an unarmed man, and they really wanted to key on that point that perhaps Tremaine Wilbourn feared for his life, but clearly the jury wasn't buying that here.
Yeah, no, I don't think it was a surprise to me and most of the people that were watching. I think the evidence was pretty overwhelming that he was not going to be able to make out a self-defense case. And I think we all assumed that we were headed towards the death penalty phase. In fact, when I was on, we had talked kind of about the second stage, assuming that the first stage was going to be guilty.
And now we should note what's happening today is the sentencing phase. So the jury came back with that guilty verdict, and Mr. Wilbourn came back and said, listen, I will take a deal with life in prison without the possibility of parole, and I will extinguish all of my rights for any appeals. In exchange, I don't want the death penalty. I'll go life without life in prison. The Bolton family came back and said, we reject that. We want to pursue the death penalty. And that's what's going to happen today, continuation of the sentencing phase. What do you think about that?
Well, you know, when it comes to these type of cases, obviously, when I was a homicide prosecutor, obviously, you always want to take the victim's family's opinion, into consideration when you're making a decision. I'm not sure that it's their right to make the final decision because they're not, they're not the prosecutor. But obviously, you're going to consider what they have to say. The one benefit I think about is the idea of not being able to make any appeals is huge. This case could go on for years and years and years if this is a death penalty, if he ends up getting the death penalty. And so I think, look, I understand I could never step into the victim's family's shoes. But there's, I hate to say benefits to both. That's a horrible, there's no good choice. But there's certainly benefits to the idea of making the conviction completely concrete and not appealable.
Okay, well, let's talk now about the sentencing and what's happening. We saw last week the testimony of Officer Jacoba Boyd from the Memphis Police Department, who provided an impact statement in this sentencing phase. Take a look. Okay, we're listening to the different statements that were made during the sentencing phase in the Tremaine Wilbourn case. I'm back here with Law and Crime trial analyst Julie Rendelman. Julie, final thoughts as we continue on with the sentencing phase today. Again, we expect to be live at 10 a.m. Central Time, 11 a.m. Eastern Standard Time. What can you expect for the rest of the day?
Unfortunately, I don't think we're going to be hearing much good on the part of the defendant. He's not only been in trouble before this crime happened in a brutal bank robbery, of which I believe he was on probation for it, as well as whatever he did, he had in the car that caused him to decide it was appropriate to take the life of a police officer. Plus, he has been unable to control his violent behavior while he's incarcerated. All these things that come together, I think, is going to be very difficult for the jury to find that he should not.
It's a difficult job for them. And Julie, thank you so much. We can't wait to have you back on. We're taking a quick break. We'll be right back.